Do you understand? You need to speak up.
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state. Oh, 6708, State versus Kaylee Vader, or is it Vader?
Vader, miss.
Vader.
Yes, Your Honor.
Can I have parties announce?
Danielle Pambrick for the defense.
And are you Miss Vader?
Yes, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Vader, did you review the true bill of indictment with your attorney? Did you understand it?
The best of my ability, yes, ma'am.
Well, this is the document. That's the indictment. It tells you what you're charged with. Did you review that with your attorney?
I believe so.
Well, we're not doing I believe so's. Either you did or you didn't.
Yes, yes. Yes, Your Honor.
So this document tells you what you're charged with. Did you review it with?
The hearing opens with a tone of quiet formality. The judge calls the case State versus Kaylee Vader and asks the parties to identify themselves. Defense counsel Danielle Famberg announces her presence, and the defendant timidly responds, "Yes, ma'am." From the very start, Kaylee's voice trembles, polite, unsure, and heavy with nervous energy. The courtroom feels tense yet controlled, the kind of silence that makes every "yes, ma'am" sound louder. Have you ever noticed how a person's tone in court can reveal more than their words?
Your client? I'm sorry, with your attorney?
Yes, ma'am. I believe so.
All right. Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, off the record. Mr. Reitmeyer?
Yes, ma'am.
So your client thinks, your witness thinks they're in the waiting room?
That's what I'm told. He's joining now. That's what I just got.
All right, because he's not in the waiting room. You may want to make sure that you have the right number. All right, we're back on the record. Ms. Vader, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with fraudulent use or possession of identifying information less than 5 items as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court.
The judge begins to question Kaylee. Did she review the indictment? Does she understand the charges? Did she discuss everything with her attorney? Kaylee hesitates, saying, "I believe so," but the judge quickly cuts her off. "We're not doing I believe so. Either you did or you didn't." That sharp correction changes the room's energy instantly. It's a clear reminder. Uncertainty has no place in front of a judge. You can feel the imbalance, a powerful court, a small voice trying to stay steady. Do you think Kaylee's hesitation shows confusion or guilt?
Does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Vader, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
The legal language continues. Rights to a jury trial, cross-examination, the right to remain silent. Kaylee agrees to waive them all. She pleads guilty to fraudulent use or possession of identifying information, a felony punishable by up to 2 years in a state jail and a $10,000 fine. Every "yes, Your Honor" feels automatic, like she's just trying to get through it. This is the point where the courtroom's emotion turns from formality to quiet resignation.
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's a $2,000 fine. There are no applications. The state will take in consideration 2025 PF 25525. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? You need to speak up.
Yes, ma'am.
As the plea terms are reviewed, we learn her sentence: 1 year in a state jail facility and a $2,000 fine. The judge reminds her that she's giving up her right to appeal. Kaylee answers softly but firmly, "Yes, ma'am." The formality almost hides the weight of what's happening. Her freedom is being decided in real time. Behind those calm exchanges lies a life about to change completely. Would you remain this calm if your future was being decided in seconds?
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that you have no contact with Janaya, Krista, Ortega. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest, Your Honor.
State any evidence?
Yes, Your Honor. City Exhibit number 1 with all the attachments.
No objection, Your Honor.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Now comes the emotional turn. The judge asks if Kaylee has anything to say. Her answer is hesitant. "I'm sorry. It caused inconvenience to my sister." But the judge doesn't let that slide. It's more than an inconvenience. "Why would you use her cards?" Kaylee quickly denies it, claiming she never used them, only gave her sister's name to police. Suddenly, the calm courtroom shifts into confrontation. This is the moment the truth and lies collide. Who do you believe here, Kaylee or her sister?
Ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your?
Kaylee struggles to explain, saying she doesn't remember much because she was in septic shock at the time. The judge reads from the police report. The sister said Kaylee herself admitted it. There's a pause. The judge's disappointment is visible. You can almost feel Kaylee shrinking under the weight of her own story. It's one of those courtroom moments where emotion feels heavier than evidence. Do you think Kaylee's memory loss is real or a way to escape blame?
Your client.
We'd ask the court to call the evening. Your Honor.
All right, anything you wish to say? Miss?
Other than, I was causing inconvenience to my sister.
All right, it's more than just an inconvenience. Why would you use her cards and everything?
I didn't use her cards, Your Honor. All I said was I just gave her name whenever the police questioned, because this was the nature of this was so bad that I guess they called the cops. And my assumption, I don't remember anything really, honestly. I was in septic shock by the time they kind of got me. I don't remember where I was.
Well,
I
no,
don't
you,
remember the conversation really or
according to the
anything,
police report,
but,
your sister said you called her and you told her she was gonna be mad
this was
because
this
you
was
used her
after-
information.
I'm sorry.
Thank you.
I'm sorry, Your Honor.
No, here's the thing.
The judge shifts the focus. When's the last time you had employment? Kaylee admits she hasn't worked since her daughter was born and breaks down describing how she lost everything: her daughter, her home, her stability. I ended up out on the streets and doing drugs, she confesses. It's a painful, honest moment, raw and human. For a second, the courtroom stops feeling like punishment. It feels like grief. Do you think addiction excuses the crime or just explains it?
When's the last time you had employment?
Since before my daughter was born, I was a stay-at-home mom
And where's your daughter now?
with her dad, with her.
And how old is she?
father. She's 8.
All right, and what have you been doing with your life? Be honest.
Since I came into the system, I tried to follow probation. I had a job and all that, but I wasn't prepared for how empty I'd be without her, and I ended up out on the streets and doing drugs.
All right, so no, here's the thing. I
And
understand
that's
you're,
not me, but
I understand you're saying that's why you ended up on the streets doing drugs, but there's more going on. And if you want to be in your daughter's life, you're going to have to make better choices. This is what the court is going to do. The court is going to sentence you.
The judge listens carefully, acknowledging Kaylee's pain but refusing to ignore her choices. If you want to be in your daughter's life, you'll have to make better choices, the judge warns. The sentence stands: 1 year in state jail, $2,000 fine, and no contact with the victims. The judge recommends the therapeutic community program, a small chance at real recovery behind bars. A justice meets mercy here, as a balance few courts ever find. Would you call this punishment or a second chance?
To 1 year in the state jail facility, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. Take in consideration 2025 PF 25525. There's to be no contact with Janae Kirsta Ortega, and I'll recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, when you're released from custody, if you can't find a sober support house to stay in or transition housing, and I'm still here, you can come back here and I'll find a placement for you. But if you
Before closing, the judge offers Kaylee something rare: hope. She tells her that once she's released, if she can't find housing, she can come back to the court and the judge will help her find placement. That line hits hard, a moment of compassion from a system often seen as cold. This isn't just a sentence, it's a lifeline. Do you believe the judge's kindness could actually help Kaylee change?